Hello everyone and welcome to today's Mondaq webinar in association with Fabian Privacy Legal, who will be explaining the preparatory measures for the implementation of the new Swiss Data Protection Act, which will come into force on September the 1st, 2023. My name is Dan Sampaio and I'm joined by the brilliant Daniela Fabian to take us through today's discussion. Daniela is the founder and executive director of Fabian Privacy Legal, a boutique law firm specialized in international, European and Swiss information and data protection law, governance, risk management and program implementation. Daniela is a Swiss attorney at law, certified privacy professional with more than 30 years of professional experience. She advises multinational companies in the EU, Switzerland and the USA on data protection and security issues. Now, before I hand over a housekeeping item, you can submit questions to Daniela by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible during our Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Daniela to begin. Thank you.
Thank you, Dan, for this introduction, and welcome also from my side. So this webinar is actually built on a previous presentation that I held in December last year. And in the previous presentation, I explained already all the concepts of data protection. So the main concept of permission to process personal data subject to prohibition. I discussed personal data controller, processor, processing, profiling, the privacy by design concept. We talked about the privacy principles, the obligations of the controllers, of the processors. I also outlined the requirements for outsourcing and cross-border data transfers, and I finally gave also a recommendation. Now, the previous presentation can still be accessed via the Mondaq platform. So in this webinar now, I will not go into all these details again, so I will not explain again the concepts, but I will focus more on the implementation steps that organizations need to take now in order to be ready in September for the new law. Also, I will focus only on the preparation and obligation of private organizations, so companies, but not federal bodies. So our Swiss law covers both, so the obligations of the private companies and of federal bodies. But as I said, we will just focus on the private companies. Next slide, please. So the first question that all organizations need to ask, and I saw also from the list that there are many organizations from outside Switzerland, is actually whether the Swiss federal data protection law applies to the organization. And now in Switzerland, we have an impact principle, basically. So in order to assess if the law is applicable, the organizations would need to do a test, let's say. So if the organization is located and registered in Switzerland, then the law applies. If the processing takes place in Switzerland, then the law applies. If natural persons are affected by this processing, even if the processing takes place outside of Switzerland by the organization outside of Switzerland, then again, the Data Protection Act applies. If none of these requirements are met, then in principle, the law does not apply. Next slide, please. So the next question is to assess if a representative must be appointed. Many of you may know it from the GDPR that organizations outside of the EU must under certain circumstances appoint a representative, and we have the same requirement in Switzerland with some different conditions, but it's the same principle. So private controllers or companies located abroad must designate a representative in Switzerland to act as the point of contact for the data protection authority, so the Federal Data Protection and Information Commissioner, FDPIC, and also for data subjects. but only if certain conditions are met. So first, the organization processes data of persons that are located in Switzerland. And the data processing is connected to either offering goods or services in Switzerland or monitoring the behavior of these persons. You know this from the GDPR already. And the processing is extensive. Generally, this will be the core processing activities of the organization. And it is a regular processing, so not just an occasional processing. And the processing involves a high risk for the personality of the data subject. So there are a lot of conditions here. They go beyond of the conditions under the GDPR. So it will not be often probably that organization must really appoint a representative. Next slide, please. So what do organizations need to do? So first, of course, assess if the Data Protection Act actually applies to the organization. And if yes, then assess if a representative must be appointed in Switzerland according to the criteria that we just saw before. Now, if a representative must be appointed, then it is the recommendation to do this in writing. There is no obligation to do this, but it's recommended, of course, to do this in writing and also to specify in writing the duties of the representative. And the duties, basically, they are in the law, is to keep the register of the processing activities. The content of that is listed in the law, but we will come to that in a couple of minutes. Then the representative must also provide information to the Data Protection Commissioner if the Commissioner asks for this, and on request also provide information to data subjects on how they can exercise their privacy rights, but also on request. The name of the representative must be published. Best thing is to do that in the privacy notice. Next, please. Okay, so the next step is to see if you need to appoint a data protection advisor. Now, in Switzerland, under the new law, it is not mandatory to appoint a data protection advisor. This is really up to the organization to decide whether you want to do this or not. Now, the data protection advisor is shall be the point of contact for data subjects and the authority, so the Data Protection Commissioner. And the task is basically to train and advise the controller on data protection issues and also to assist in the implementation of data protection. So assist also in developing policies and processes, and also in conducting some monitoring activities just to ensure that, that the organization complies with the Data Protection Act. Now, there is a benefit actually to appoint this data protection advisor. So under the Swiss law, there is an obligation also to conduct some data protection impact assessments, especially when there is a high risk processing activity. Now, if an organization conducts this data protection impact assessment, and after the assessment it results that there is still a high risk, then the organization must go to the Data Protection Commissioner and consult the Commissioner about this. If the organization has appointed a data protection advisor, then there is an exemption and the organization does not need to go and consult with a Data Protection Commissioner. This, in this case, however, now we're still in the same, in this case, however, the data protection advisor must fulfill some conditions. Data protection advisor must have a professional independency and get no instructions from the organization. There cannot be any conflict of interest. The data protection advisor also needs to have the professional knowledge about data protection, about security and related matters. And the contact details of the data protection officer advisor must be published, again, best in the privacy notice, and the data protection authority must be notified. Now, when you can select whether the advisor shall be an internal person, so an employee, or if the advisor shall be an external person. Of course, with the external person, there is, it's clear that there is independency, and maybe the external person has more expertise. If it is an internal person, then it must be ensured that there is no conflict of interest. So generally, it should be nobody from the executive committee. It should not be somebody from the HR or IT function or any function that regularly processes personal data. But it could be, for example, also a combination between the information security officer and the data protection officer, or eventually the compliance or legal responsible person together also with a data protection advisor. So there are various combinations that can be done, but not having anybody within HR, IT, and so on. This is the same criteria as you know under the GDPR already. Next slide, please. So what do you need to do? Basically determine whether it makes sense for your organization to appoint a formal data protection advisor. And this is recommended for those organizations that perform high-risk processing and therefore also must perform and carry out data protection impact assessments. For these organizations, it's really recommended to appoint somebody. And for the other organizations, it's really up to you to decide if you want that or not. But of course, it makes sense in any case to have somebody and to allocate the responsibility for data protection within the organization, even if it's not an advisor. But it's important just to think about this and to have one or maybe a larger team, depending on the size of the organization, that really deals with data protection matters. If you decide to appoint a data protection advisor, then best is, of course, to ensure that all the requirements that we just saw before are fulfilled. Again, it is recommended to designate the data protection advisor in writing. It's not obligation, but again, it's a recommendation. And the data protection advisor should be provided with the necessary resources and also get access to all information and all documents, systems, and so on that the data protection advisor needs to fulfill his or her tasks. And also it should be facilitated that the data protection advisor can go to the highest management or administrative body with data protection issues or for important questions. Next slide, please. Okay, now a very important amendment in the Data Protection Act is the duty to provide information to data subjects. Under the current law, this is only the case for sensitive personal data or for personality profiles. So for more high-risk processing activities, but with the new law, this information is a duty, an overall duty, so everyone needs to be informed about the processing of their data. There are, however, exceptions, and again, there are more exceptions than under the GDPR. So there are exceptions where information is not required. And this is basically when the data subject already has the information. Maybe the data subject has been informed previously about the data processing activities and nothing changed in the meantime, so there is no need to inform again. Or if processing of the personal data is provided by law, this can be, for example, in social security laws or also in the money laundering laws, just as an example. Another exception is where the controller is bound by a legal obligation to secrecy. So like, for example, attorneys, they have this obligation, or medical doctors. So again, they do not need to inform. And also, if there is an indirect collection, so not via or through the data subject directly, but through anyone else, maybe a data broker, then if the information is not possible, maybe because the data subject is even unknown, the identity, or if this information requires a disproportionate effort, then again, it's not necessary to inform. Then there are also situations where the duty to inform still exists, but can be restricted or postponed, basically. This is, for example, when the measure is required by overriding interests of third parties. Maybe there was an internal investigation, data subject wants to have the report, but there are other information in there that must be protected. So then, for example, it could be a reason for maybe postponing the information. When the information prevents the fulfillment of the purpose of the processing, maybe if you want to detect a crime, for example, or there are other examples that we could think of. And finally, when the controller has an overriding interest and does not disclose the data to third parties. Now, in this context, third parties, so group companies, are not considered third parties in this context. So if one of these conditions apply, then an information is not necessary. Of course, you can still do it, especially here, when even if somebody has information, you can still inform, but it's not necessary. Next slide, please. Exactly. So what do you need to do? Basically is, first of all, to determine who needs to be informed. So are there any exceptions that applies to your organization, or maybe to some of your data subjects, or not? So you have website users, for example, if you have a website, employees, job applicants, customers, suppliers, consumers, patients, etc., depending on your organization. And so for each of these, you should just decide, do we need to inform, or is there an exception that we can benefit of? If you inform, then you have to ensure that your privacy statements contain all the required information. This information is again also listed in the law. So you need to provide the controller's identity and contact information. If you have appointed a legal representative and/or a data protection advisor, it's recommended to include this in the privacy notice as well. You have to define and describe the purpose of processing, the recipients or categories of recipients of personal data. If the data is collected via third parties, also the categories of personal data. For cross-border data transfers, the state and applicable transfer mechanism, or the exception. Here it's really important to say in which countries this data is transferred. Even if it is from Switzerland to Germany, this needs to be stated in the privacy notice. If there is automated decision making, so decisions that are based only on automated processing and that have a legal effect on the data subject, then these data subjects must be informed as well. So if you know that you do this, then you should include this information as well in the privacy notice. And then finally, any other relevant information that ensures transparency and the exercise of the privacy rights. So data retention, for example, how long is the data retained? Eventually, you can also say, how to exercise the privacy rights. This is not an obligation. It's different than under the GDPR, but these are elements that, of course, you can include. For the notifications, for the privacy notice, it's important to look at the deadlines. If it's a direct collection, you have to notify at the time of collection. If it's an indirect collection, then you should notify not later than 1 month after receipt of this data, or if you decide to transfer that data or disclose the data to somebody else, then you need to do it at this time. Now, so very important, inform. This needs to be done before September 1st. This means review your privacy notices if you have already privacy notices. Many organizations have implemented privacy notices based on GDPR, others may not. So review what you have. If you don't have the privacy notices, create privacy notices with these content. Privacy notice, of course, for employees, that's one. And then for your website users, customers, suppliers, and so on. Here you can decide whether you want to have just one website privacy notice, including also all the information for the customers, suppliers, and so on, or if you want to have separate privacy notices. This really depends organization by organization. Some organizations have a portal on the website with all the privacy notices, but it depends really also on the size and on the amount also of privacy notices that you need. Of course, also for job candidates, here again, it can be included in the website privacy notice, or if you have a job career portal, then maybe you have a dedicated privacy notice. The privacy notice can be posted on the website. As we said, it's important that it is visible and available for the data subjects, and also be it on the website, be it also on an app, and that there is also a reference to this privacy notice in contracts, in terms and conditions, maybe in the disclaimer of the emails, in invoices, in order forms. You can reference then to this privacy notice so that everyone really can see it and can read it. Next slide, please. Okay, so another topic which is important is the record of processing activities. Yes or no? So the requirement, yes, controllers and processors must keep a record of their processing activities. That's like the GDPR, but this is new in the Swiss Data Protection Act. Again, there is a minimum content for this record. You have to identify the controller's identity, the purpose of processing. You have to describe the categories of data subjects and personal data processed, the categories of recipients, the retention period or criteria for determining this period, a general description of data security measures, and in case of cross-border, the indication of the state and the safeguards. This is the minimum requirement, or the minimum documentation or information that you have to include in this documentation. Now, there are exemptions for companies to maintain such a record, and this is if the company has less than 250 employees, always counted on January 1st of the year, and the data processing is associated with a low risk for the data subject. So this is generally where no sensitive personal data is processed and no high-risk profiling is performed. Then we can assume it's not high risk, but of course there might be maybe other situations where there could be a high risk eventually. But generally, if this is not done, so it's just normal data that maybe you process about your customers or contact information and just general employee data, then and the organization has less than 250 employees, then in principle you do not need to maintain such a record. Next slide, please. However, why should you keep a record of processing activities? Nevertheless, I mean, this is at least my recommendation. The record of processing activity is really the basis of your data protection management. It's a basis for privacy by design. It's a basis for performing data protection impact assessment, because you always need the same information: what data, for what purpose, who has access, what are the data security requirements or measures, and so on. It's a basis to provide privacy notices and to respond also to data subject access requests. It's a basis for handling data breaches. It's a basis also often for for knowing and for managing your data flows. And also, if you have an intergroup data transfer agreement, often it refers also to the records of processing activities that really documents also in concrete what type of data flows apply. And as I said, it's the basis for data management and compliance. So for these reasons, I always recommend to keep such a record, because at the end, all organizations must be compliant anyway. I mean, there is no exemption for that. You have to do this. You have to know where your data flows. You have to know what you have. So that's why it's a good exercise. For small organizations, it's not such a big deal, because small organizations have only a few processing activities generally. And of course, large organizations, they have to do that in any case. Next slide, please. So what should you do in respect of the record of processing activities? You should determine if your organization falls under the exception. First of all, if you decide not to maintain a record of processing activity, then I recommend to document this and to keep it somewhere, so that you can say, okay, we have looked at these, of course, unless it's absolutely obvious that you don't need to do this. But if it's not so obvious, maybe, then I recommend just to document this and to document the reasoning. Then as a next step, I recommend to get an overview of all the filing systems and processing activities at corporate level and function by function, so that you know what you have. Document the processing activities and the filing systems using a template, so you can do it in a Word, in an Excel template. There are tools available also on the market that can be used to make this documentation. And you should do this really in a collaboration with, maybe if you have a data protection advisor or somebody responsible for data protection, that's good, but you need to involve all your functions, HR, IT, marketing, and so on, depending on your organization. Then I recommend also to assess the entries for completeness, just to see that really all the information is completed, and to do also a compliance check, just to see if the required obligations and the requirements are actually met. So, for example, if you transfer personal data abroad, then the compliance check would include also the verification if a transfer agreement is in place, for example, or if the data subject have been informed in the privacy notice about this transfer, and so on. Then also you should assess if a particular processing activity requires a data protection impact assessment. As I mentioned before, this would be for high-risk processing activities. And in this case, or if you also maybe want to use a new technology, or maybe engage or do automated decision making, maybe combined with the implementation of AI tools, maybe risks that have not been assessed yet. In this case, it's recommended to do a data protection impact assessment as well. Also, I recommend to allocate the responsibilities at function and corporate level to establish and maintain this record of processing activities. Without this, it's very difficult that this really is done, because it's not a fun task to do at the beginning. It helps a lot once you have it, but of course, it's a little bit a pain at the beginning to gather all the information and to do all the documentation. And also, I recommend to establish a process for regularly review these records of processing activities and to perform amendments. And again, of course, for large organizations, it's more important to have written processes and standards and so on. For very small organizations, this is maybe something that can be done also, more ad hoc, but there should be some process in place. Next slide, please. Okay, then a very important topic is data security. So technical and organizational measures must be implemented, the so-called TOMs. And here we have the law, the data protection law, but the criteria and the specifics are described in the ordinance to the data protection law. I call it here DPO. So not the DPO, not data protection officer, but DPO in the sense of data protection ordinance. So the controller and the processor must ensure that appropriate data security measures are implemented appropriate to the risks, and these measures should prevent data security breaches, ideally. The data protection ordinance contains these criteria for determining the appropriateness and protection goals. I will come to that in a minute. But the ordinance does not really specify very concrete terms or minimum terms that needs to be implemented. Then for automated processing of sensitive personal data, so data relating to health, for example, on a large scale, that's generally if it's the core activity of the organization, or also for high-risk profiling, the data controller and the data processor must keep a log and create a processing policy. I will come to that just in the next slides. Next slide, please. Okay, so what are the security principles and the goals? As I mentioned, so to ensure this, the data protection, the security of the data, the controller and the processor must determine the protection needs first of the personal data that they have, and then determine also the appropriate organizational measures according to the risk. So in a first step, determine the protection needs of the personal data. And the DPO lists some of the criteria. So it's important to assess what types of personal data do you have. So data classification is key here, meaning you should know whether you have just personal data, contact details, or general HR management data, or if you have sensitive personal data, or if you use maybe just pseudonymized data, so that you just know what you have. So this is what I mean by data classification. So you should know in your systems what do you have and classify this data. And then it's important to know the purposes. So why is this data processed, the nature, the scope, and also the circumstances of the processing. So this information helps you to identify and determine the need of data protection. As a second step, you need to determine the risks to the personality and the rights to the data subjects. And again, the data protection ordinance lists the criteria. So you have to look at the causes of the risk, to the main hazards, what measures are taken to mitigate these risks, and what is the probability and severity of data breach despite all the measures that you have implemented or that you envisage to implement. So here you have to calculate basically, or to assess the risk. And then based on this risk, you have to determine the TOMs. So the technical and organizational measures, and here for the TOMs, you have to take into account the state of the art, the implementation costs, and also to look that these measures are or can facilitate or can ensure confidentiality, availability, integrity, and traceability. More specifications are listed, as I mentioned, in the ordinance. So for those of you who want to look at what it is exactly, I recommend to look at the ordinance. Good. Next slide, please. So there are two additional requirements that maybe are also different than the GDPR. So the first one is a record or log. So the requirement is to record at least the storage, alteration, reading, disclosure, deletion, and destruction of the data if certain conditions apply. So if sensitive personal data is processed automatically on a broad scale, or high-risk profiling is carried out, and you see that the preventative measures cannot guarantee data protection. That's difficult in the practice probably to really understand when this is the case, but this is really an assessment that each organization needs to do. That process sensitive personal data or really performs high-risk profiling, that's the test to do. It must be provided a minimum content, so the identity of the person who carried out the processing must be recorded, the nature, so what has been done, the date, and the time of processing. And if the data has been disclosed to a third party, then also the identity of this recipient. So all of these must be recorded. This record must be kept for a minimum time. It must be kept for 1 year, and it must be kept separately from the system that processes personal data. And also it must be ensured that only persons with a need to know have access to this record. Next slide, please. Another aspect that is also maybe typical for the Swiss Data Protection Act is the requirement to create, in addition to the record of processing activity, also a processing policy for automated processing. Again, if sensitive personal data is processed on a broad scale automatically, or high-risk profiling is carried out. In this case, this additional processing policy must be put in place. The policy must include information on the internal organization, so a description also of the architecture and of this system and how the system works. The data processing and control procedures must be documented and the measures taken to ensure data security. Now, if this information is already documented in other documents like the record of processing activities or maybe a security policy, then in this policy you could work with references, so not repeat everything again, but just to make a reference to these other documents. It's necessary also to establish a process to regularly update the processing policy, and if a DPA, so a data protection advisor, is appointed, then this processing policy should be made available to the data protection advisor. Often the advisor will be involved in the creation of these policies, and so the advisor will know anyway about this. Okay, next slide, please. So, so what should you do, basically? So first, for data security, it's recommended that you review your data security standards. Determine, so as we said, determine your data protection needs, determine the risks for data subjects, implement adequate TOMs appropriate to the identified risks, and then assess if a record of processing policy is required. Best it's really to do that also based on the record of processing activities, and if so, establish a mechanism to ensure appropriate records and keeping them for at least 1 year separate from the system that processes personal data, for example via a separate backup or a storage also in the cloud or a separate server. Get the required information for the processing policy and document using a form, a template that includes all this required information, and as I mentioned, work with references where it's possible. And then establish a process regarding the records and processing policies, allocate the responsibilities on who really should create them, maintain them, review them, and amend, especially the policy if it's necessary. Okay, next slide, please. Good. Now we come to another aspect, which is also very important. It's outsourcing. Now, the controller may assign by contract or legislation the processing of personal data to a processor. We know that from the GDPR as well. First of all, the requirements are the data must be processed in the same way as a controller is permitted to do. So you cannot outsource something that you are not permitted to do to somebody else. And also, there must not be any contractual confidentiality obligations that would prohibit this assignment. Now, very important, the controller must ensure that the processor is able to guarantee security. So this vendor assessments, due diligence that we know also from the GDPR must be performed also under the Swiss Data Protection Act. In addition, what is new in the law, the processor may only transfer the processing to a third party, so a sub-processor, with the prior approval of the controller. So this is just the flow, the general flow. So first, you have to determine who your service providers are, and if these service providers actually are processors. Not all service providers are processors, but just those that really process personal data on your behalf and on your instruction. For example, an organization that processes email addresses to send newsletters in your name. For the processors, you need to perform a due diligence. So you need the controller, so need to check whether the processor complies with the data protection requirements and whether the processor has implemented the appropriate security measures to protect the data. These vendor assessments are generally done with a questionnaire. So it's not that you have to go on site and perform the audit, but yeah, as I said, it's performed via a questionnaire that then would be evaluated. Then, once you have done that, then you need to have a data processing agreement between the controller and the processor, and this agreement must specify all the relevant data protection and security obligations, so the instructions. The Swiss Data Protection Act does not list all the requirements of the content of this agreement. Generally, what is done is we look at Article 28 of the GDPR, take maybe these templates, but it's very important to customize these templates to the Swiss situation, if it's only for Switzerland. If data is transferred abroad, then in addition, appropriate legal safeguards must be put in place to protect that data. Yeah, next slide, please. Yeah, exactly. So cross-border disclosure. So here nothing changed actually. So the disclosure of or transfer of personal data to third countries is restricted. So it's okay to transfer the data to adequate countries. And the Data Protection Ordinance lists these countries that are considered adequate. If it's in another country, then you need to have a guarantee, so either BCRs for those companies that have this, or what is typically used are the standard contractor clauses. Now, the Swiss Data Protection Commissioner accepted the EU standard contractor clauses, so you can use them, but you have to add an addendum for some specific requirements. So this is important, EU SECs plus Swiss addendum. And in addition, of course, if the data shall be transferred to third countries like China, India, and US, for example, then you need also to perform a data transfer impact assessment. This is the same like under the GDPR. This is a consequence of the Schrems II judgment ruling. So this needs to be performed just to ensure that governmental agencies will not access this data in an unacceptable way. And then, of course, there are exceptions. You may have a consent to transfer the data and so on. Good. Next slide, please. Okay, so what do you need to do for these two areas, outsourcing and cross-border? So first of all, it's recommended that you get an overview of all your service providers and data flows, so within and outside your organization, and determine which service providers are your processors. Look at their locations, so where are they located, what services do they provide, what types of data do they process, and do they engage sub-processors? And if so, where are the sub-processors? What do they do? What data do they process? This is very important. Then second step is review existing contracts that you may have in place and evaluate whether they are still okay, whether they include all the required privacy clauses, and if not, then insert the privacy clauses, data protection clauses in your contracts. As I said, you can take the GDPR templates, if you have maybe already used those, and adapt them to the Swiss situation. Make sure that the service provider can guarantee the security, so by using a service provider assessment questionnaire. If the service provider is abroad, make sure that you have the legitimate transfer mechanism in place. So as we discussed, EU standard contractor clauses with the addendum, for example, and perform these transfer impact assessments before transferring the data. For the US, we may have a solution, hopefully soon, in a couple of months, but for other countries, like for example, China or India, we still need, of course, to do all these transfer impact assessments and also having this extra transfer mechanism. For internal data transfers, again, of course, it's important to conduct the transfer impact assessments as well and to have a transfer mechanism. Many large organizations, they put in place intergroup data transfer agreements, and some organizations have BCRs in place. Okay, next slide, please. So this is basically the last thing, data protection standards and processes. To ensure compliance in your organization, it's not a legal requirement to do this actually, but it's a strong recommendation, is to implement data protection policies or a data protection policy outlining the general privacy principles, the obligations and the roles and responsibilities for data privacy, and also to have some processes in place for handling and documenting certain aspects, especially data subject access requests. As you may know, there is this right of data subjects to request access of their information, and the company must provide this information within 30 days. So it's important to have some process in place to ensure that this is done correctly. For very small organizations, of course, a written standard may not be necessary. For large organizations, this is really recommended. Then processes also to handle data security breaches. Again, under the Swiss law, now there will be a duty to notify data protection or data security breaches to the Federal Data Protection Information Commissioner via a dedicated portal that is already available, and eventually also data subjects. Again, it's important to have some minimum process, at least also for small organizations, to handle this type of data security breaches. Then some processes for privacy by design. So that means that when you have a new project or a new system, that you look from the beginning what types of of privacy requirements must be implemented. Very important also for outsourcing and cross-border data transfers, especially for large organizations, that you have some processes in place to conduct the vendor assessments, transfer impact assessments, and so on. Data storage and deletion. So how long should you, or may you keep your personal data, and when should you delete it? When should you anonymize it? How is it done, etc. So this is also important to think about this. And then also to have some regular reviews of compliance with data protection requirements. Again, here, if there is some process to make sure that once per year your records of processing activities is again reviewed and maybe amended. That would be very, very recommended. So implement some directives, some SOPs regarding data protection, compliance, security, and also governance. Very important, train all the employees, and also eventually consider obtaining a confidentiality data secrecy confirmation from employees that regularly process personal data, especially if there is maybe some more sensitive and also secret data that should be kept confidential. But it's not an obligation, this is just a recommendation. Next slide and last slide. So here on this slide, I have just put together on a high level the recommendations. On the left side, you see in red where there is a personal liability. If there is a violation, green does not mean that you do not need to do this, but green just means that there is no direct liability under the law. But of course, you may still have a reputational risk or an indirect liability at the end. And on the right hand, I try to put the priorities on what maybe should be done first, and other things maybe also a little bit later. So first, assess if a new law applies to you. I think this is very urgent to do this. Conduct a data management and compliance analysis to identify potential gaps, risks, and required actions. Assess if a representative must be appointed, and if so, appoint. Determine if it makes sense to appoint a data protection advisor, and if so, do so. But that's something that you can do also after September, that doesn't matter. Determine who needs to be informed, and then review or create data protection privacy notices and inform the person. That's very important, and here you will be liable if it's not done correctly. Establish the records of processing activities. Again, very important to do this. Also determine if in certain situations you would need a legal basis. This is not always the case. Perform compliance checks and establish if a DPAA is required. This again is something that you should do. Once you have the record of processing activities, then do these assessments. And then very important, where there is also liability, review your data security safeguards, conduct assessments to determine the level of protection and the risks, determine if you need to have privacy, to have logs or processing policies, and if so, then implement. Review your relationship with your vendors, look at your data flows, review your contracts, make sure that you have the vendors assessments done, the transfer impact assessments done if required, and that you have the contracts in place with your data processors. Determine if internal data flows are done, and if so, if you have the appropriate mechanism, and also establish a process and responsibilities for data handling, data subjects, requests. Now, these which are red are really all the obligations that if you violate them intentionally, then you could be liable up to 250,000 Swiss francs, and it's a personal liability. So it's not the company, but it will be the person that actually is responsible for taking these decisions. And then finally establish other policies as I listed here, and also implement the policies and and train the people. So I finished. I hope you have some questions. I know it was a lot, but please.
Excellent. Thank you very much, Daniela. And before we move on to our Q&A, I just want to thank you for that excellent presentation and for sharing your insights and your knowledge. We really appreciate it. So we will now move on to our Q&A. And if you do have a question for Daniela, please do share it now. It's a wonderful opportunity to have it answered. Our first question: do we need to obtain the consent of data subjects when processing sensitive personal data or performing high-risk profiling?
Yes, so this is an important question, and there is often a little bit confusion about this. But no, in general, under the Swiss Data Protection Act, there is no requirement or general rule to get consent. So this is really only in specific cases. However, if, for example, personal data is processed against the privacy principles, so for example, you process data, so in this case now, as you said, sensitive data or profiles, maybe, yeah, you have not informed about this, for example. So you do that against the privacy principles, or you violate data minimization principle, or if personal data is processed against the will of the data protection of the data subject, or if sensitive data, in this case, it would be sensitive data, would be shared with third parties. In this case, you need to have a legal justification, and consent can be one of the legal justifications. And because we talk about high-risk profiling and sensitive data, this consent should then also be explicit. But only in these situations. As a general rule, no consent is required.
Brilliant. Thank you for that answer, Daniela. Can the data protection advisor be an external party?
Yes, the data protection advisor can be an external party. That's the same like under the GDPR as well. So you can really select. So large organizations generally appoint somebody internal. Small organizations maybe tend to appoint an external privacy advisor. As I mentioned before, there can be benefits to have an external. The advisor is independent. Usually the advisor has also expertise in data protection and so on. And the internal, of course, yeah, has other benefits. But what is really important, if you appoint an external data protection advisor, it's really very important to involve that advisor into your organization. So it's not about just appointing somebody and then it's done, but you really need to involve this person within your processes and showing them also the systems so that the advisor really can perform the job. That's really important.
Excellent. We've had a couple of questions in just now, and I think that we have time to answer them. Daniela, I will read them out for the audience, but if you want to look at them, you'll be able to find them in the chat. Kamoyo asks, is deletion of information considered a breach if the information is deleted before a year lapses?
Is deletion of information a breach if the information is deleted before a year lapses? Well, it depends. No, it's not a breach. I would say no. It's not a data security breach, and the year there is no defined retention period for keeping personal data. So the retention period basically is as long as you need to process that data for your specific purpose. That is a retention period. So if you delete that data, maybe you may have other issues, but I would not consider that as a data security breach. Unless, of course, there might be a situation, of course, if the information should be available, but is not available anymore, but it should be available, then it could be a security breach. That would be then an availability security breach. So that could be, yeah, this could be one case.
Yeah, excellent. And in all of these cases where we have questions in, if you do want to reach out to Daniela for further discussions or more information, you have contact information there, and we will be following up with an email with all of the contact information for Firm and Daniela after the webinar. We've had another question in from Bobby, and I think we'll have time for that before we wrap up today. Bobby has asked, is there a requirement for the data protection advisor to be based in Switzerland, or can that individual be based in another country?
The advisor can be based in another country. And of course, advisor must be somehow reachable, must speak languages. But I mean, we speak a lot of languages in Switzerland. So that's the criteria, but it can be somebody abroad, yes.
Excellent, brilliant. Looking at that, looking at the time, I think that we will need to wrap up there, Daniela. As fascinating as this has been, we really appreciate your time today. Daniela, do you have any closing comments or any key takeaways that you'd like our audience to leave today's session with?
No, well, first of all, thank you for giving me this opportunity, and for everyone, if you have questions or so please reach out via Mondaq or directly to me. I think you have the contact details, and I'm happy to respond to any other questions that you may have. Thank you.
Excellent. Thank you again, Daniela. It's been a pleasure to have you with us as always, and thank you to our audience for being with us today. I wish you all a lovely rest of your day and say goodbye.
Goodbye. Thank you.